everybody. Good evening. We'll just wait a minute while folks trickle in. We are very glad that you're joining us. My esteemed colleague, Jess Braverman, and I are glad you're with us.
Hey
Jess, tell
everyone.
me about your shirt as we wait for
Oh,
people to come in.
yeah, I've got my Minnesota Lynx shirt on. They recently won the Commissioner's Cup, which is like a mini competition within the season. And Gender Justice was their nonprofit organization that they were donating to. So they got big money, we got big money, and we got to watch them win. And it's just lovely. I love that team. They're so cute. They're so like
Ooh,
happy they get along so well this year. They play well together.
they're
What a
so
great team.
badass. Yeah, like what talent. I love it. Minnesota Lynx, we love you. Um, Well, I think that we're gonna get started. So welcome everybody. Thank you for joining us on rather short notice to talk about the Supreme Court's decision today in Moyle v. United States, or better known as the EMTALA case. Jess and I'm Erin May Quade. I'm the Special Projects Advisor. Jess, would you like to introduce yourself?
Yeah, I'm Jess Braverman and I'm the legal director at Gender Justice.
And Jess is my longest esteemed colleague, as I always say. We are going to talk about the decision. And in order to get us to the decision, I think we should just spend like 3 minutes on background on what this case is. So, Jess, what is this Entala case?
Yeah, what is this EMTALA case? So like every case in front of the Supreme Court, you're like, what is it? I'm like, yeah, what is it? Because these cases are just ridiculous. It's ridiculous that they're making it to the court. But EMTALA is this law that requires emergency rooms that accept Medicare funding to stabilize patients. Basically, they can't turn patients away. So if someone comes to them and they need emergency medical services, and the hospital's like, well, this isn't cost effective for us. They don't have the best insurance. They don't have any insurance. They're on Medicaid. Like, we just want to turn them away. You can't do that. EMTALA says as long as you accept Medicare funding, which like every emergency room does, you've got to treat patients. You can't just like transfer them and say like, well, there's someone else's problem now.
Right.
So on the other side of that, now we have all of these states with abortion bans with varying degrees of exception. So Idaho has an abortion ban with an exception for the life of the pregnant person. But what about the health of the pregnant person? Because sometimes you need emergency stabilizing medical care, and sometimes that care you need is an abortion. Otherwise, you'll lose your ability, future fertility. You could,
Your
go
kidney
into
function.
kidney function. Yeah, you could go into sepsis and develop very severe problems if you don't get an abortion. And so under EMTALA, the idea is if someone comes to the ER and the stabilizing care that they need in that moment is an abortion, you have to provide it. You can't send them away. But under Idaho's abortion restriction, that same care is illegal. So the question then is, do these two laws conflict? Which, yes, they do. And when two laws conflict, which one controls? Typically, the federal law does. And so typically, in a more normal universe where we have like rule of law and we're in the United States of America, the court would say, well, we have the supremacy clause. That means that federal law trumps state law. And so EMTALA, this emergency law, trumps Idaho's abortion ban. And to the degree that it does, like you have to provide this abortion care. So what's happening is um hospitals that are scared because they're going to be subject to criminal penalties under Idaho's abortion ban are literally airlifting pregnant people out of the state, like not just transferring them to another hospital in Idaho, like airlifting them out of the state to get care elsewhere because of Idaho's abortion ban. And so that's what's been going on in Idaho. It's awful. You've heard that news, right, Erin?
Yes, and when this case was argued, I believe in April, at the time, our Solicitor General Elizabeth Prealoga, who there is nothing but love for her on this channel, she talked about how there had been one pregnant person airlifted out of Idaho in the entirety of 2023, and by the time this case was being argued in 2024, in April, 6 pregnant patients had been airlifted out. So it was having immediate and devastating consequences. I think that one thing that's really important to note is that lower courts, so when this issue was brought in lower courts, the lower courts, didn't they put an injunction or a stay against
Yeah,
Idaho's
so
abortion ban.
so
Mhm.
basically there was a lawsuit, and the question in the lawsuit is like a pregnant person comes in, she's not necessarily going to die if she doesn't have an abortion, but she's going to be very severely injured if she doesn't have an abortion. She really needs that care. What controls EMTALA that requires the hospital to provide it to her, or Idaho's law that prohibits them from providing it to her? So that's the question in the lawsuit. The lower court, gave a somewhat normal opinion that said, well, these two laws conflict. Federal law trumps state law when that happens because of the supremacy clause, and so EMTALA controls. And so what that lower court said was, look, hospitals, you can continue to provide emergency abortion care under EMTALA. They didn't strike down Idaho's abortion ban, but they said if someone comes to an emergency room and they need that care, you can provide it because EMTALA requires that. So that's what the lower court said.
And then the Supreme Court accepted cert or said, we're going to hear this case. And then what did they do to that lower court ruling?
So they said, we're going to hear this case, and in the meantime, we're going to take that lower court ruling and put it on pause. So while we putz around waiting for briefing and arguments and whatever, Idaho emergency rooms can't provide emergency abortion care, which is terrible. And so for these months that the Supreme Court did that, that's when people were being airlifted out of Idaho for care. Like imagine you show up in an emergency room, you or your partner, right, is pregnant, they're bleeding, they're hemorrhaging, they're showing up in an emergency room, and the doctor's telling you, I know how to provide this care. I'm competent. I have everything I need to do it, but I can't. So you're gonna have to get in a helicopter, an airplane, and like be brought to another state for this care. It's horrifying.
While you're losing your
While
pregnancy.
you're
I mean,
yeah,
that is,
while you're
oh,
having a devastating pregnancy emergency. Like it's
yeah.
awful, and it's the reality.
Yep. And so, okay, so we put this, the Supreme Court put this law on, or the ruling on hold. The abortion ban is in full effect, meaning that pregnant patients who are showing up to Idaho ERs aren't getting stabilizing abortion care if they need it, in anticipation of the Supreme Court coming out and having a decision on what happens if you have an abortion ban that doesn't allow for stabilizing medical care. And today the Supreme Court issued their decision. What did they say, Jess?
They said, you know what? Like, nah, we don't really want to decide this. It's 2024, it's an election year. And the last time that we messed with abortion in an election year, it didn't go so well for us conservatives. So what we're going to do is we're just going to say, like, never mind, case dismissed. And it's not that the case isn't dismissed, just the cert to the Supreme Court. They sent the case back to the lower courts. They lifted their stay, which means the lower court's ruling is in effect, so people can get their life-saving, health-saving care now. But for all of those months, like they just sat on it, they waited, they let there be briefing, and all those months people were suffering for what? And it's very unusual for the court to accept a case, take briefings, hear oral arguments, and then say like, never mind, we should have never agreed to hear this in the first place. It's awful.
It is. And I think, one of the things when we talked about the EMTALA arguments in the last, this last SCOTUS chat, one of the things that we said was in 2022, we had said there's no way that they overturn Roe v. Wade. They'll gut it, but they're not going to overturn it that close to an election. And they totally misunderstood how pissed people were going to be. And they know now. And like exactly what they did was decide to not decide in order to not have what will be their decision, which I assume will be coming in subsequent litigation, which will say, of course, EMTALA does not allow you to provide stabilizing abortions in emergency
Well,
rooms. You should die if you're pregnant and can't, live through your pregnancy.
that was the Alito dissent. And so
Yes.
there were three opinions. There was there was an opinion uh agreeing like, yes, we're gonna so the court overall as a whole dismissed the case and lifted their stay. There was a bunch of judges signed on to one opinion explaining why they did that. Like the liberal judges had an opinion explaining why they did that. Then there was Ketanji Brown Jackson's amazing partial dissent, partial concurrence, where she's like, this court is off the rails, I can't deal with you people anymore, and we'll talk about that. And then there was the Alito dissent. And so there were three separate, like, were there four? There were a number, there might have been four. There were a bunch of different, basically like it's a free for all, but there was like a pretty horrifying dissent in this case and a pretty fiery concurrence slash dissent from Ketanji Brown Jackson.
And I think Ketanji Brown Jackson continues to be one of the best writers and jurists that this country has ever known. Sotomayor has amazing dissents. Kagan has amazing dissents. Like, do not get me wrong, but Ketanji Brown Jackson has a way of saying the thing and keeping the main thing the main thing. Will you like just read some of Ketanji Brown Jackson's quote?
Yeah, so she was really upset. And one thing she says is the court is shirking its duty based on attorney representations that defy reality. So, like, what she's basically saying is there's these court opinions saying we're going to dismiss this because when the lawyers came in front of us, they argued, like, actually, Idaho and the federal government are not that far apart. Idaho's law is broader than you may think, and the federal government, EMTALA, doesn't require abortion in like quite so many circumstances. But these are just things lawyers say. Like, they have to be actually grounded in the facts. Like, typically, if I go to court and I argue and I say something that's like not supported by the facts, not like a real thing, the judge is supposed to ignore it. Like, I can't lie, right? But if I just say something that's true, but it's not even part of the factual record of the case, what the court should really do is ignore it. Instead, the court punted the case over like this lawyer chit chat. It never should have done that. And so what she's saying is basically the reality is that people are being airlifted out of the state. It's a nightmare. There is clearly a conflict between EMTALA and Idaho's abortion ban. We see it every day and it's harming people. Like, why are we pretending that's not happening? Because lawyers come in here and say, we're actually not that far apart. Like, you are, and it's impacting people, and we need to address this. And so she accused the court of shirking its duty, but she got fierier than that.
Yeah, I'll read the next one that and she's really laying into the fact that the court intervened, lifted that putting the conflict on hold. She said, we simply cannot wind back the clock to how things were before the court injected itself into this matter. Our intervention has already distorted this litigation process. We permitted Idaho's law to go into effect by staying the district court's injunction in the first place, then allowed this matter to sit on our merits docket for 5 months while we considered the question presented. It is too little, too late for the court to take a mulligan. Like,
A mulligan.
I know.
Yeah.
That was really fiery to me. And then, she really gets to the last part too, essentially calling out the political nature of it. Do you want to read that
Yeah,
quote?
so she says, will this court just have a do-over, rehearing and rehashing the same arguments we're considering now, just at a comparatively more convenient point in time, which is about
Mhm.
as like pointed as you can get, right? Because you know what she's referring to, Erin.
Yes, there is a point in time in November that is that the conservative justices know that their fellow conservatives are suffering at the ballot box because of their extreme positions on pregnancy care. And they're hoping to wait until after the election to issue devastating rulings in cases about Miffy, in cases about EMTALA, and pretty much anything else. I'm sure there'll be a devastating case about Comstock that will come up. So that is what she's calling out, and that is what happened. Like, we shouldn't pretend like, the court was like, we just don't have enough information. That's not what happened. They had full briefings, oral arguments. They had the time to make the decision.
Eh,
And the reason that they chose not to say you can provide stabilizing abortion care in emergency rooms in states that have abortion bans is because they're going to come back and say you can't. They just don't want to do it before an election.
Also, like, how horrifying. They didn't have enough information at the end of all this, but like they had enough information in just like a cert request, right? Like a written
Mm.
petition to literally undo a district court ruling and put people's lives in jeopardy. Like that's terrible. But there was a pretty horrifying dissent. And then we should also talk about this in the context of what they said in the mifepristone case, because
Yes.
it doesn't feel like we live in it's like we do not live in a civilized society anymore. So do you want to start with the dissent in this case, and then we could get into, so in
Yes.
this case, there was Alito, Gorsuch, and Thomas, basically saying that EMTALA doesn't require abortion care. And if you read their opinion, they're very, very transparently like, just because, like, for in life in general, right? You go to the emergency room and the doctor says, this treatment, here's the risks and here's the rewards with this treatment, right? Like there's side effects, there's benefits. If you get it, you might die. You know, if you say no to it, you might die. If you say yes to it, you might die. Here's the percentages, right? And at the end of the day, you get the information you need to make an informed decision. That's how medical care is supposed to work. You're like, you go in, the doctor needs to make sure you understand what they're telling you, and then you decide, and they help guide you through that decision. But not if you're a pregnant person in like the US in 2024. In that case, like what the dissent basically says is like, they never really know for sure that you're gonna die. And so like without like complete certainty you're gonna die, like why don't they just not give you the abortion? And that's not how medical care works. It's really horrifying, right? Like in life in general, if there's like a 90% chance you'll die without treatment, you get the treatment, right? Like, or you have the option at least to get the treatment. It's up to you.
And what's interesting is that Alito and the dissent put health of a pregnant woman in quotes, like actually put the word health in quotes. I mean, that was to me the like disdain and misogyny for women and people with uteri was just disgusting throughout. And really truly, I think if I was going to say the I guess the crux of Alito's argument is basically that like EMTALA requires hospitals to treat pregnant people and their fetuses the same. And so if a person's dying because they're pregnant, well, that's too bad. Kind of ignoring the fact that, I mean, really downplaying how dangerous pregnancy complications can be, and even called out PPROM, which is premature rupture of membranes, which is very, very dangerous and can be very, very life-threatening. And he like mansplained the differences between like threats to health and threats to life. It was pretty horrific. And the fact that Gorsuch, Alito, and Thomas signed on to this and were like, absolutely, like this is basically the roadmap for the arguments for what other Matthew Kacsmaryk has teed up for whatever comes next. And it was very fetal personhood forward, to borrow a phrase from some of my favorite lawyers.
It was very dehumanizing, and it fit really well with what they said in the mifepristone case. So I know we just had a webinar on this, but I just want to remind folks what that case was really briefly. There was a ridiculous challenge to undo the FDA's approval of mifepristone, which is one of two medications used in medication abortion. Mifepristone's extremely safe. It's effective. It was approved in the year, or Mifeprex, it was approved in the year 2000, and it's been on the market ever since, and it's extremely safe. A group challenged that approval. I laugh because that's not a thing, but they did. And the Supreme Court took it far more seriously than they should. And what the Supreme Court did was they ultimately dismissed that claim. But what they said was the doctors who brought this, their emergency room doctors who said, like, one day someone might be given mifepristone and then they'll have an emergency and we have to treat them and that'll involve us giving an abortion. And so this affects us. We have a right to bring a lawsuit. And the Supreme Court said, no, you don't. And you would think what they would say is mifepristone's so safe that it's really unlikely that anyone's going to show up in your emergency room under these circumstances, right? But instead,
or the circumstances under which people show up in your emergency room is not the basis for which they get care. But what they did say was,
so what they said instead was you don't have standing because if you have a religious objection to abortion, you just don't have to provide it, even if someone's going to die. Like if someone's going to die on the floor of your emergency room when you're perfectly capable of caring for them and you don't want to, then so be it, right? Like that's horrifying. That's a horrific ruling.
Correct me if I'm wrong, but it wasn't just abortions, right?
It was like if you have a religious objection to anything, you don't have to do it. It was really broadly stated. The statutes they cited for that proposition did not support that. The statutes they cited were far narrower, but they were like, this isn't a problem because you just don't have to save anyone's life. Like you're just an emergency room doctor. It's not
of course you have to agree with every single thing about that person's life and the medical care they need in order to provide it.
And I found it so offensive. Like, look, I was a public defender. Like my grandparents were in the Holocaust, right? And as a public defender, I would represent a Nazi. Like it was my job. I didn't like what they do. I don't like who they stand for and who they are. And I fundamentally disagree with it. But I took a job. Like I took a job to serve people and provide something I think is really important, which is criminal defense. Everyone has that right. Everyone has a right to a competent attorney if their government charges them with a crime. And so I would take their case, right? I take people who do LGBTQ hate crimes, and I'm proud that I did that work. I have absolutely no regrets. The idea that you go into like the job of an emergency room doctor and be like, really prefer to leave these people dying on the floor bleeding out, like that's horrifying, horrifying.
And what other, I mean, I'm just trying to imagine a world in which there were other kinds of medical care that people could say they objected to. Like, what if it was, somebody who got in a car accident and needed a hysterectomy because they were hemorrhaging? If they were like, I actually don't want to mess with a person's fertility, they're going to die. I don't believe in blood transfusions. You have a testicular torsion from a bike accident, but I don't want to mess with your, I mean, the cascading effects are not unknowable. And right now it's abortion, right? But it'll be something else next, and it'll be bigger and broader, and it'll come to impact more people. And I hope people understand that this wasn't the end goal. This wasn't like the last part. It's just the beginning of an absolutely terrifying future that the anti-abortion movement and white Christian nationalist movement would like um, to have be real. Okay, so one of the questions I'm going to have for you, Jess, is, North Dakota and Minnesota. Those are the two states that Minnesota, or that Gender Justice does our work in. Today's decision, what does it mean for Minnesotans? What does it mean for North Dakotans?
Oh, that's a great question. So for Minnesotans, we don't have an abortion ban on the books. There's no law prohibiting any doctor from providing abortion care to someone who shows up in an emergency room or in an abortion clinic, or wherever the venue that they show up in. So we don't have that ban on the books. So it's not an issue here. And because the court didn't actually rule on what is or isn't required under EMTALA, I would argue like the most reasonable, logical, and sensible interpretation of EMTALA does require abortion care in an emergency. Like it requires whatever the standard of care is if someone shows up needing emergency care, and sometimes that is abortion. And so in my view, EMTALA would still require emergency rooms to provide that care. For the folks who only have access to religious hospitals, it was already a dangerous situation. I was reading reports from I know there was an ACLU report. There's reports from like 2010, 2016, from when, and I don't mean like individual reporting. I mean a book of reports of this happening, of even with Roe v. Wade in place, even before Dobbs, people were being turned away from emergency rooms at Catholic hospitals when the care they needed was abortion care, and it would lead to them like bleeding out, hemorrhaging, like all sorts of terrible, terrible stuff. And so I don't want to pretend like this is a new thing. This is something that already was unfortunately happening, but I'm worried now that with the Supreme Court's pronouncements and support of these kind of horrifying views that it's going to increase, and I'm not looking forward to seeing that.
Yeah. So Minnesota, abortion remains legal, whether you're showing up at a clinic with an appointment, whether you're showing up at an emergency room with a, emerging medical need. North Dakota, tell us about what's happening in North Dakota. What does this mean for North Dakotans?
Yeah, so in North Dakota, there is an abortion ban in place. Gender Justice with CRR, the Center for Reproductive Rights, and Weil, a law firm, are challenging North Dakota's abortion ban, but North Dakota's ban is not quite as extreme as Idaho's. It does have more exceptions that would allow for some abortion care to definitely protect the life, both states, to protect the life of the pregnant person, and then to some degree to protect the health, but it doesn't necessarily, like, these abortion bans are vague, right? Like, what does it mean to need abortion to save your life? Does that mean like imminent, like you're going to die today if you don't get it? Does it mean you're going to die down the road if you don't eventually?
Does it mean you're going to die in an hour or like in 8 hours?
And how certain does the doctor have to be that you're going to die? Because it's not a yes or no, right? Like it could be 80% if we do this, and 20% if we,
Right.
It's these laws aren't written to be clear, and they create a lot of chaos and fear among providers, which is a huge part of the problem. But North Dakota does have an abortion ban. I know folks from North Dakota in need of an abortion do come to, among other states, Minnesota. They can continue to do that. Folks can continue to come here to Minnesota to get abortion care. I think North Dakota There's not a lot of abortion care available right now while this case plays out. But we are hopeful. There's a trial on that case in August, and we'd love to see that ban overturned. CRR, Center for Reproductive Rights, is doing a fantastic job. They're taking the lead on this case. And we know we're all gonna work our hardest at that trial, and we're hoping to see that ban overturned.
And what this means, I will say, for Idahoans, is that they can receive a stabilizing abortion care in their emergency rooms. But what this also means for Texas is that Texans cannot, because the Fifth Circuit, the worst circuit, I would say, it ruled that Texas can flout EMTALA. And that means that the people of Texas, if they show up in an emergency room, Texas emergency rooms don't have to provide life-saving and stabilizing care. So because there is now a split, the Supreme Court will hear this again. So will this case come back after the November election? Of course it will. And I think today's non-decision signals to me that there is a decision here and it's bad. It's bad and people will not like it. They're just going to make it less close to an election, when Republicans might end up losing elections. So that is,
Yeah, so this
that's
case
just
could
true.
also, so the Texas case could go in front of the Supreme Court if they accept review on that case. Right now, there's a ruling that I think the guidance, basically the guidance saying EMTALA does include emergency abortion care and places have to provide it. Right now, based on the Fifth Circuit ruling, I believe that doesn't apply to Texas because of their ruling, and the Supreme Court could end up hearing that issue. The Idaho case isn't over. The case is going back to the lower courts, so it could make its way right back to the Supreme Court. So basically, like, after all this and all this pain they put people through and all these arguments, they punted until, I guess, it's not an election year anymore, which
Yeah. To
is
do the
really
exact same thing that they've already done, which is accept cert, do briefings, do oral arguments, and
right.
issue an opinion, right? There's nothing new that they need to have made a decision. They just decided not to. There is a question about how does this ruling impact people seeking gender affirming care, or does it?
That's a great question. I think the component that would probably affect folks the most is the issue from the Miffy case of what happens if a hospital. So there's it's a complicated question, right? Because there's two scenarios. There's one where you have a provider saying, I don't believe in gender affirming care, I'm not going to provide it. And we know gender affirming care is life-saving care, but that doesn't mean it's not typically care you get in an emergency room. You know what I
Right.
mean? Like it's that doesn't mean it's not life-saving, but it's not like the thing you need to stabilize because you're in a car accident or you have an internal bleed. It's life-saving important care, but it's not typically like emergency room care. So the question then becomes, how far do these religious exemptions go? Do they let you deny gender affirming care to a trans person, or do they let you deny care to a trans person? And that's the really scary distinction, because there are cases in the US. There was a case in the US where I think a trans man was it ovarian cancer, I believe, and
Yes.
like the hospital would not treat that person, and I believe they died. And so there are situations, there's two different things that could happen. One is like, I will not provide an abortion care, and one is I will not provide any care to anyone who's had an abortion, right? And so it's like, how
Right.
far is this going to go? And that's pretty terrifying. And so I think this is a scary situation. But I think hospitals already turn people in need of, like, there are scenarios where, and unlike with abortion care, unlike emergency care, like gender affirming care is kind of a separate issue. It's not typically what you'd contemplate with EMTALA, because it's not typically emergency stabilizing care, even though it's so crucial as care. And so it doesn't directly impact gender affirming care in that sense, but I'm very worried that doctors are going to feel like they have a license to turn away people. And the reason I feel that way is it's not just in my head, right? Like, in addition to the example we gave, when you go to the legislature, you hear arguments like, am I going to have to let a trans person use my food shelf? Am I going to have to
Right.
let a trans person use the bathroom at my church? And it's like, excuse me, like, is this what you want to do? Like, turn hungry people away from food shelves? But it's things people say in legislate. Like, we know there are folks, it's not common, right? But there are folks who want to do this. And so that makes me very, very nervous. And so in that sense, like, it's scary.
The
instance.
one thing that comes to my mind as well is, part of the case in the Miffy case that the doctors, I'm going to put them in quotes because like people, one of them was a dentist. So, not all of them are emergency room physicians, but like, the doctors who brought the case, um, the thing about mifepristone and having a medication abortion is that it is indistinguishable from having a spontaneous abortion or a miscarriage. And so essentially what those doctors were saying is that someone might come in and they might be experiencing a miscarriage, but I won't know if if they took Miffy. And so they wanted to distinguish between providing care that they actually would provide to somebody who was experiencing, the right kind of abortion, versus somebody who took Miffy. And so to me, what that says is that they really are trying to wind down this path of like, this doctor needs to agree with you and your life and what's happening that brought you here in order for them to provide you care. And I think that the Alliance for Hypocritical Medicine, it's Hippocratic medicine, but it's hypocritical medicine. I think that's what they're trying to open the doors to and that's the whole point
Well, and it's
of the
not just that,
society they want to create.
it's
Yeah,
not
go
just
ahead.
that, it's also what's care, because
Mm.
Justice Jackson during oral arguments was like, well, what, you don't want to give them like a bottle of water? Like, what is it
Oh
you're asking
yeah.
to be allowed to not do? And so it's like, what even is care? Is it like, do you have to like do anything at
Is it the
all?
procedure or is it anything related to the
Anything at
person?
all? Yeah.
Basically what we're saying is that we have seen over and over again this raising of it's actually the person. It's not becoming the procedure. It's becoming the person and whether they agree with, I don't know, that person's life and blah blah blah. So that's where I think this is headed, or it's where it is, right? It's just the
We're
quiet
just
part.
like barreling into a theocracy, and it's
Yes.
horrifying. And like I
Yes.
say this as a Jewish person, right? Like the grandchild of Holocaust survivor, like it is horrifying that we are barreling into a theocracy. And I like to think that most churches I like in my neighborhood are, they have signs outside, all are welcome here. I don't know what people preach from the pulpit, but they're not trying to keep gay people out of their bathrooms or whatever it is. I don't think it's a the majority of religious folks, it's just the loudest, right? Like it's the ones who are the most resourced, who are bringing a lot of litigation. And it's really unfortunate because I think, Erin, you're Lutheran.
I
Is
am.
that,
Yes. We just
and
had Pride Sunday last Sunday.
you're Lutheran. Like, it's really unfortunate that like this is what religion is turning into in the
Yeah.
public arena. Like, I hate that.
Yeah, I mean, we saw with Louisiana posting the Ten Commandments in the public school classrooms today. Oklahoma said that they're going to literally teach the Bible, which my question is always, which one? There's lots of different versions of that Bible. It becomes this thing where it's like the execution of a Christian theocracy will be very interesting because there's lots of different facets of Christianity. But the start of this is horrifying, and it's not like I am Lutheran. Last Sunday at our church was Pride Sunday, and we talked about gender expansive people and acceptance, and that's what we talk about from our pulpit. So a world in which people access abortion care and have gender affirming care is a world that is in line with our vision of our religion. And so it's actually a violation of our religion, the way that this is happening.
Well,
But that never gets brought up.
yeah, I went to a great documentary tonight. NCJW, National Council for Jewish Women, put it on, where they showed a movie called Under G-D, because in Judaism you don't spell out the name or say it. And so it was about Jewish folks in Indiana and Florida bringing lawsuits, basically saying our state's abortion ban violates my religion. Like, what about me? Like, in my religion, a fetus isn't a person until it's born, and if someone needs an abortion, they need an abortion. Great. And under my religion, you have to give it to them, right? Like, you
Yeah.
have to save a life. Like, you have to do this. And so it talked about those lawsuits going on, and it's great to hear that perspective.
Yeah, it is. And I think that it's going to demand, people of faith, of multiple kinds of faiths, to step forward and be like, whoa, 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 whoa. Like, stop co-opting my religion, my faith, to push your version of it on all of us. That's not what we're trying to do. And I don't want to be part of it. It's important. It's an important piece of it, but we are barreling towards this Christian right-wing theocracy at an alarming pace. And I think it happens in these pockets, or in these like random one-off news stories. And it's helpful if people can see it as all part of the same movement. It's all one umbrella. It's all towards the same goal. And they've ticked off a lot of a lot of like to-dos on their checklist, but they have more. And I think collective action, rising up against it, being really clear about what it is and how harmful it is, that is how we stop it. So that's my little pitch.
Well, we also have another idea to stop it, which is why we're pushing for an inclusive ERA.
Yes.
And the ERA is the Equal Rights Amendment, and we are hoping to Gender Justice is pushing for a version of the ERA that is inclusive. It expressly says that it protects like the right to become pregnant, remain pregnant, not remain pregnant, pregnancy outcomes, decide for your own. Like we want to protect contraception, abortion, IVF, all of those things. We want to make sure folks are protected. And so we're trying to push an ERA, an Equal Rights Amendment that is inclusive of that. That way, if our judges in the Minnesota Supreme Court one day decide, like the US Supreme Court did, to say, we're not gonna, like we change our minds, abortion's not
Right.
protected. We could say, well, yes, it is. Look at the ERA, it's right in there. And so that's one thing that we're doing, to try to protect our rights here in the state, right? Because we brought that abortion lawsuit challenging Minnesota's abortion restrictions under the Minnesota Constitution, because we were worried there wouldn't be abortion rights under the federal Constitution for much longer. And we were successful. That ruling came down 2 weeks after Dobbs, and it meant that people had in need of abortion care had a place to go. They could, they shouldn't have to travel, but they
Yeah.
did have to travel, and they could come to Minnesota when Wisconsin stopped providing, Iowa stopped providing, North Dakota, South Dakota, right? All of our surrounding states stopped, but it was still protected here, and we want to keep it that way.
There's a question about the effect of the effects of, I believe, abortion bans on medical education. And I can talk a little bit about this. So silly me, right? I assumed that when you become a doctor, that in order to be a doctor, particularly an OB-GYN or an emergency room physician, that you had to be trained in all the things that you do there. What we're about to see in the next year to 2 years is the first classes of medical doctors who will be medical doctors, who will have, OB-GYNs, emergency room physicians, who will not have received training on how to provide abortion care. And they will not have received that training because they attend colleges, universities in states where there are abortion bans. And so it's not just that, oh, I can just travel to another place to go learn this. In order to travel to receive training, you have to get med mal insurance, you have to have a place to like be located, you have to, residencies and match it, like there are a number of spots, right? And you have to have a patient population. And so it is actually very, very difficult right now for medical students and residents to make sure that they're getting the full spectrum of care. And so when you're reading stories about their medical students and residents are not choosing medical schools or residency programs in states where there's bans, it's not just because they're like, I don't want to live under a ban, it's scary, which it is. And a lot of OB-GYNs are women of reproductive age, so they themselves might need access to abortion care, but it's because they won't have the training to actually be medical doctors by going and having a residency in a place where they legally can't learn the full spectrum of care. So we are about to experience in the next year and 2 years, the first residents and medical doctors who will not have had training in a critical piece of pregnancy care in large swaths of the state. There's a lot more there, but it is a huge issue that medical students for choice and the reproductive health doctors are raising, especially because we know that much like every other industry, the medical profession is graying, and we have a lot of retirements that are happening and are going to happen. And so if we're going to have new residents and doctors who don't have this training at all, it's going to endanger every pregnant person's life, whether EMTALA lets you have stabilizing abortion care or not. If you're getting airlifted to a hospital, they're like, I never learned how to do this. Or you show up in the emergency room and EMTALA lets you have stabilizing care, but your provider's like, I don't know how to do this because I legally wasn't allowed to learn. That's what the big concern is within the concern in a medical community.
Erin, there's a question for you.
Yeah.
Can Erin touch more on what happened to the ERA this last year? I thought it was going to pass. I too thought it was going to pass.
I too thought it was going to pass. So what I can tell you is that there are the votes for it to pass. What there wasn't this past year was the time for it to pass. So the Senate passed a version in 2023 that was very short, right? And when it went to the House looked at it and rightfully so said, I don't think this is doing what we want it to do. It'll eventually do it what we want to do once we have litigation after litigation to get the courts to add language to this to interpret this constitutional amendment. But the House really did a lot of work, and the House author did a lot of work with our Senate author to basically spell out what would we want the Equal Rights Amendment to say. And then the Senate or the House spent, gosh, like 15 hours debating that. They over multiple days. We are the only state legislature in the nation that does not have time limits on debate, but we do have limits on the number of legislative days. That's a little out of balance. So by the time the House passed it and sent it back to the Senate, we were entering our final days of session. And the hope was that we could pass our conference committee reports, which were there and waiting and ready, and then pass the ERA and then have it go to the ballot. We ended up having like 10-hour discussions about conference committee reports that came back with identical language, except one thing was out. We were hearing like 9-hour stories about copper wire. I mean, there was a lot of filibustering that was going on. And so when we got to the very end of session, the choice was to ram it through and put it on the ballot without debate in the Senate, which I think would be a disservice to the ERA, and it would have been a disservice to Minnesota voters. Or come back and do it next year. And so we are going to come back and do it next year. The short answer is we ran out of time, which is deeply unfortunate, but we didn't run out of will or support. And so we're going to keep pushing and get to it next year.
Every time you talk about the legislature, I learned something new, because my knowledge before I met you was I'm just a bill and I'm sitting here on Capitol Hill. And like every time you explain like how things actually work, I'm like, good Lord.
It is rules and processes and all of those things that make the legislative process both good for democracy, but it can be slow and it can be confusing for sure.
And for people who aren't our age, that was Schoolhouse Rock, by the way, if we have any younger listeners.
I'm elder millennial. Yeah, I guess I'm sure anybody like Gen Z.
Yeah, I also can't sing. So like when these two issues combined might make it hard to identify what was going on there.
And also every member of the Minnesota House and one seat in the Minnesota Senate are up for re-election this year. So talk to your candidates or your House representatives, because keeping the Minnesota House is going to be, and the Senate, actually, we are currently a split Senate until the former seat of former Senator Kelly Morrison is filled. Then we can't put it on the ballot. So that is, the election is our next big part of making sure the ERA gets passed, is making sure that we return pro ERA legislators to the legislature.
And we see here in the chat, but this plan to do it next year depends heavily on winning the House. If we fail, it's not likely to come back. And I'm just part of the legal department. I don't know what I'm allowed to say or not say, but yeah, I agree. Like it whether it passes depends very much on who is in government. I think I can say that much.
Yes, you can.
Yeah. So yes, that's absolutely correct.
Yeah. And that was Representative Kristen Bonner, who is just a wonderful partner of mine in the House, who I love working with on so many things, including the inclusive ERA. Well, I think that we have sufficiently bummed people out. But you know what? It's not our fault. It's the Supreme Court's fault. It's the Supreme Court's fault. And tomorrow will be, I believe, the last day of decisions. There will be some doozies, including the immunity case.
I think they added Monday. I think
they did. Okay. I thought they would do like Friday news.
We've got some terrible stuff coming up. There's the immunity, but then there's also this case about like our administrative state, like
Chevron.
Whether like who knows better about medical care, like 80-something-year-old judges with no medical training, or like the specialists who are employed by government agencies
at the health department.
It should surprise you. Yes, it should surprise you little that the judges think they know best, and there's huge concerns that they're going to expand judicial power and limit the power of the agencies and regulations and things. So we have that to look forward to.
Yes,
a theocratic judicial, like I don't even know what you call that. Like it's like where your
fiat.
Yeah.
it's really concerning as a lawmaker, right? Like you write a law, you basically write out like what's supposed to happen, but the way that it happens is through rules and regs that agencies do, right? Like I was the chief author of the READ Act. It's a literacy bill for all of Minnesota. There's a lot of pieces in it, but like how, like the rubric that the council uses to look at the curriculums to say that I didn't put that in statute, that would be bananas. They put that together. That's a rule, that's a reg that the department goes through. The way that Chevron goes is like, yes, the department has this authority to kind of like fill in the how, and undoing that, which I think a number of justices have alluded to in their opinions. They've dropped some kernels to prepare us for that getting overturned. There's the January 6th case. There's the do presidents have unlimited immunity for crimes they commit, which today was I'm just going to end with this. Today was the really interesting decision on bribery versus gratuity for elected officials. What
That
the
was
Supreme Court
yesterday.
said, or that was yesterday? Okay, I
Yeah.
don't even know my days. But essentially it said, if you give an elected official money before they do something for you, that's bribery, that's illegal. But if an elected official does something for you and then you give them money as a tip, a gratuity, that's not illegal.
If
That's
they
just
fly you
normal.
on their private plane after you ruled
Yeah.
in their favor, then
Yeah.
that's okay.
There is nothing more anathema to like how I live than that. But can you imagine being like, if you give me the money, just hold on to the money, then I'll go do the thing and then give it to me after. Like, how is that not bribery? Whatever. We're gonna have to like make sure our laws in Minnesota really have that buttoned up. I'm sure they do, but the Supreme Court's really on some bullshit. Let me just tell you that. So we will be back with a SCOTUS chat when there's more to update. But I think that brings us to the conclusion of our repro cases for this term.
Yes.
So,
though a lot of things are like repro impactful or repro adjacent,
correct.
but those are the two cases that we flagged as like being directly on point on abortion. And but we'll have updates about other things in the gender justice brief.
Yes, we will. Thank you so much for
Yeah,
joining
thank
us.
you all.
Everybody, enjoy your night. Have a good Pride. Have a good 4th. We will be with you all soon.